A very good morning to all my dear students. Today we are going to discuss a very important concept, and that concepts are the concept of Mesne profits and return statement as given under the Code of Civil Procedure 1908. Before starting with the said topic, I would like to recapitulate the points which we have covered till date. Till date, as you all are aware, we have already covered with the introduction part of the Code of Civil Procedure, wherein we have discussed about the historical background behind the enactment of Code of Civil Procedure and also about its amendment thereon. Thereafter, we had also discussed about certain definitions given under Section 2 of Code of Civil Procedure, like judgment, decree, and order. Today, we are going to continue with the said definitions. As such, we are going to explain about the concept of Mesne profits and return statement, which are a very important part of this particular subject. Hope you all will learn a lot from it. Now, I would like to start with the today's lecture, that is on Mesne profits, and thereafter I will discuss about the concept of return statement. As far as the definition of Mesne profit is concerned, it has been defined under Section 2, Clause 12 of the Code of Civil Procedure. Now, it means or it includes those profits which the person in wrongful possession of such property actually received or might with ordinary diligence have received therefrom, together with interest on such profit, but shall not include profits due to improvements made by the person in wrongful possession. And the nature of this Mesne profit is that of compensatory nature, but which is penal in a nature, meaning thereby its object is to compensate the person who has been kept out of possession and deprived of enjoyment of his property, even though he was entitled to the possession thereof. Now, very important question which a law student must know is that against whom the Mesne profits can be claimed. It can be claimed or person in wrongful possession and enjoyment of immovable property is liable for Mesne profit and enjoyment of immovable property. So from this, we may infer that Mesne profits can be claimed with regard to immovable property only. Thus, a decree for Mesne profits can be passed against a trespasser or against a person against whom a decree for possession is passed, or against a mortgager in possession of mortgaged property after a decree of after a decree for foreclosure has been passed against him, or against a mortgagee in possession of property even after a decree for redemption is passed, or against a tenant holding over at will after a notice to quit has been served upon him. So these are the persons against whom we may infer that a suit for Mesne profits can be claimed or against whom a suit for Mesne profits can be filed. Now, next point which one should know, and that point is what is the test or how will you determine whether the plaintiff would be entitled for Mesne profits or not? The test is not what the plaintiff has lost by being out of the possession, but what the defendant has gained or might reasonably and with ordinary prudence have gained by such wrongful possession. The next very important question which one should know is that whether an interest can also be claimed. Answer: since interest is an integral part of Mesne profits, it has to be allowed in computation of Mesne profits itself. So my dear students, this is all about Mesne profits. Now I am going to discuss with the second portion, that is the concept of written statement. As far as the word written statement is concerned, it has not been defined in the definition clause which is given under Section 2 of the Code of Civil Procedure. Now, then what is the meaning of written statement? The meaning is it is a reply of defendant to the plaint filed by the plaintiff. Meaning thereby, it is a pleading of defendant dealing with every material fact of a plaint. It may also contain a new facts in favor of defendant or legal objection against the claim of a plaintiff, meaning thereby it is a pleading of defendant. So the next a very important question which needs to be answered over here is that, is there any time limit for filing the WS? Answer is yes. 30 days is the time limit to file the WS. Now, from which date this 30 days period needs to be calculated or computed? As far as the computation of this time period of 30 days is concerned, it is submitted that, or it is relevant to point out that this 30 days period is to be computed from the date of the service of the summons on the defendant. Now, the very next important question again comes to my mind, and which also needs an answer over here. Whether this 30 days time can also be further extended. Answer is again yes. It can also be extended by a period of 90 days. Now, what are the particulars to be contained in the written statement? Number one is defendant is bound to produce all the documents in support of his defense along with the WS. So it is his duty when he is going to file his defense or his reply to the plaint, that is the defendant herein, to submit all the documents which are in his possession, and thereby to satisfy the requirements laid down under the CPC as well as under the Evidence Act, that is under Section 63 to Section 65 of the Indian Evidence Act 1872. So on this point, there is an interconnection between the Indian Evidence Act and the Code of Civil Procedure. Whether the defendant can also file any other documents apart from the WS? Answer is yes. He may also file a set-off or a counterclaim, which I am going to deal with the same in my subsequent lectures. As far as the particulars to be contained in the WS is concerned, it is pertinent to mention herein that the defendant has to deny the facts specifically and not evasively. In case he denied the facts evasively, then it will tantamount to admission. And as you all are aware, that admission has also been defined under Indian Evidence Act, and that is under section 17 of the Indian Evidence Act. So there is relationship between Indian Evidence Act and CPC. Next, no pleading other than by way of defense to a set off or counterclaim can be filed. Next, is there any leading case? Yes, there is a leading case, and that leading case is that of Balraj Taneja versus Sunil Madan. What did you mean by set off? A claim set up against another. It is a cross claim which partly offsets the original claim. In this, where in a suit for recovery of money by the plaintiff, the defendant finds that he has also a claim of some amount against the plaintiff, he can claim set off in respect of the said amount. Illustration: A sues B on a bill of exchange for rupees 5,000. B holds a judgment against A for rupees 1,000. The two claims being both definite and pecuniary demands may be set off. Now, what are the conditions to claim set off? The suit must be for recovery of money. The sum of money must be ascertained. Such sum must be legally recoverable. It must be recoverable by the defendant or by all the defendants. Further, it must not exceed the pecuniary jurisdiction of the court in which the suit is brought. And both the parties must fill in the defendant's claim to set off the same character as they fill in the plaintiff's suits. Now, what will be the effect of filing the WS or filing the set off or claiming the set off or counterclaim? When the defendant pleads set off, he is put in a position of the plaintiff as regards the amount claimed by him. There are two suits, one by plaintiff and against the defendant, and other by defendant against the plaintiff, and they both are tried together. If plaintiff fails to get relief in his suit for any reason whatsoever, it does not affect the claim for set off by the defendant, and a decree may be passed in favor of the defendant if he is able to prove his claim. So this is all about today's lecture. Hope you all have learned a lot from this lecture. Now, I will apprise you with the new topic which I am going to deal with in my next lecture. In my next lecture, I am going to explain the concepts of foreign court, foreign judgment, res sub judice, res judicata, as given under the Code of Civil Procedure. Thank you very much. We'll meet you soon.